Hello and welcome to the Minimum Competence episode for Monday, August 25th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Intel's $8.9 billion deal with Trump, the rearrest of Kilmar, Abrego, a sanctuary city's ruling, and a patent fight over Apple Watch imports. Let's remember, autumn is a second spring where every leaf is a flower, and read today's legal news. On this day in legal history, August 25th, 1916, President Woodrow Wilson signed the Organic Act, formally establishing the National Park Service, or NPS, as a federal bureau within the Department of the Interior. This act marked a foundational moment in U.S. environmental and administrative law as it created a centralized agency responsible for protecting and managing the country's growing number of national parks and monuments. Prior to this, national parks were overseen in a disjointed manner by various federal departments, often with limited resources or clear guidance. The Organic Act provided a legal authority for the NPS to, quote, conserve the scenery and the natural and historic objects and the wildlife therein, while ensuring that they remained, quote, unimpaired for the enjoyment of future generations. This statutory language introduced a lasting legal standard, the dual mandate of conservation and public enjoyment that has guided U.S. park policy ever since. The law empowered the federal government to enforce regulations, manage visitor access, and develop infrastructure while preserving natural and cultural resources. Over time, this act laid the groundwork for the modern administrative state's role in environmental regulation. It also reflected an early recognition that public land could and should serve both ecological and civic functions. The NPS Organic Act helped inspire future legislation, including the Wilderness Act of 1964 and the National Environmental Policy Act of 1969. It also fueled legal debates around resource extraction, tribal land claims, and federalism. With the stroke of Wilson's pen, the United States committed itself to a legal philosophy of stewardship, enshrining the idea that public lands are a shared national trust. This day in legal history commemorates the birth of a legal and cultural institution that continues to shape American land use and environmental governance. Skadden advised Intel Corp in securing an $8.9 billion government investment deal, which includes granting the U.S. a 10% equity stake in the chipmaker. The agreement, announced by President Trump, comes months after Skadden and 8 other major law firms pledged nearly $1 billion in free legal services in coordination with the White House. These services support causes such as veterans advocacy, fighting anti-Semitism, and promoting justice system fairness. The firms reportedly entered the arrangement in part to avoid being targeted by executive orders that had been used against competitors. Skadden's role reflects its ongoing alignment with the administration's industrial and legal policy efforts, particularly as Intel seeks revitalization. The Federal Circuit also recently ruled that the Patent Trial and Appeal Board, or PTAB, wrongly dismissed one of Intel's patent invalidity arguments against a competitor, bolstering Intel's broader legal position. Separately, Kirkland & Ellis, another participating firm, has been involved in U.S. trade negotiations with Japan and Korea, facilitated by Trump advisor Boris Epshteyn. The president has indicated he may rely further on these firms for legal matters related to tariffs, coal, and defensive law enforcement. Skadden's leadership emphasized internally that the firm retains full autonomy in client and case decisions. Kilmar Abrego, a 30-year-old migrant whose wrongful deportation to El Salvador had made national headlines, was detained again by U.S. immigration authorities in Baltimore just days after being released from criminal custody in Tennessee. His 2019 asylum protections had barred deportation to El Salvador due to threats from gangs, but he was nonetheless removed in March in what officials later admitted was an administrative error. After months in harsh Salvadoran prisons, he was later brought back to the U.S. in June to face criminal charges for transporting undocumented migrants, to which he has pleaded not guilty. Upon checking in with ICE in Baltimore, Abrego was arrested again and is now facing possible deportation, this time to Uganda, a country with no connection to him. U.S. officials have reportedly offered Costa Rica as a destination if he agrees to a guilty plea, but without that, Uganda remains the likely alternative, a move his legal team argues is unconstitutional and coercive. His lawyer described the tactic as the government using Costa Rica as a carrot and Uganda as a stick. Abrego has filed a federal lawsuit to prevent deportation without judicial review and is currently protected by a Maryland court order requiring 72-hour notice before any removal to a third country. His legal team is also seeking to dismiss the federal charges, alleging selective and retaliatory prosecution tied to his earlier challenge of the unlawful deportation. A Tennessee federal judge previously found him neither a flight risk nor a public threat, supporting his release. The case continues to spotlight the legal complexities and rights violations emerging under the Trump administration's immigration policies. A U.S. federal judge has blocked President Donald Trump's administration from withholding federal funds from over 30 sanctuary cities and countries, including Los Angeles, Boston, Chicago, and Baltimore. The ruling, issued by U.S. District Judge William Orrick, expands a previous injunction from April that protected 16 jurisdictions. These cities had challenged 2 executive orders signed by Trump earlier in the year, arguing they unlawfully threatened to strip funding unless local authorities cooperated with federal immigration enforcement. Sanctuary jurisdictions typically limit how much local police assist with federal civil immigration arrests. Judge Orrick ruled that the executive orders posed an unconstitutional coercive threat by conditioning federal funding on compliance with federal immigration preferences. His new order extends protections to additional cities that recently joined the lawsuit. He emphasized that any further actions or executive orders pursuing the same goal are likewise blocked under his injunction. The Trump administration had already appealed the earlier ruling, and the White House has not commented on the latest expansion. Separately, California Governor Gavin Newsom is suing over Trump's deployment of the National Guard to Los Angeles following protests related to federal immigration enforcement. A recent legal dispute between Apple and medical device maker Masimo is testing the boundaries of U.S. Customs and Border Protection's, or CBP, authority in enforcing patent-related import bans. The case began when CBP seized 5 Apple Watches in Chicago due to an International Trade Commission exclusion order issued after Masimo successfully argued that Apple's blood oxygen sensor infringed on its patents. However, CBP later approved Apple's software workaround, which shifts blood oxygen processing to a paired iPhone without notifying Masimo, prompting the company to sue. Masimo argues CBP overstepped its enforcement role by effectively ruling on a patent dispute without adversarial process, thereby undermining the ITC's authority. The lawsuit claims the workaround still infringes under the doctrine of equivalence, which treats minor design changes as infringing if they achieve substantially the same result. Legal experts note that CBP is not equipped to handle complex questions of indirect or contributory infringement, which could occur when a product only violates a patent when used in combination with another device. The case raises due process concerns, especially as CBP's later ruling was issued ex parte, that's without Masimo's input, despite an earlier inter partes process. Legal observers see this as part of a larger structural flaw in how CBP and the ITC coordinate enforcement of exclusion orders. The ITC has acknowledged the lawsuit and may intervene, signaling that the dispute could influence broader agency practices. If successful, Masimo could seek enforcement penalties from the ITC, potentially up to $100,000 per day. This litigation follows a rare legal path similar to a 2013 Microsoft case against CBP that ultimately ended in settlement. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here tomorrow, and until then, remember, autumn carries more gold in its pocket than all the other seasons.